Good afternoon and welcome to the Employer Link webinar series presented by McAfee Taft. My name is Brad Neese, Managing Editor of Employer Link. Today our focus is on tackling complex health plan coverage issues that are triggered by a reduction in hours worked when an employee goes on leave. Our presenters will discuss the myriad of health plan and COBRA coverage issues that come into play with FMLA leave, Oklahoma workers' comp leave, military leave, and non-FMLA leave. They'll also share practical advice for drafting a legally compliant leave policy. Our presenters today are McAfee Taft employee benefits lawyers Bill Freudenrich and Brandon Long. Both work with employers of all sizes in designing, analyzing, and implementing cost containment strategies for company-sponsored health and wellness plans. Their areas of expertise also extend to retirement plan design, deferred compensation, healthcare reform, and the representation of clients in audits and investigations by the IRS and U.S. Department of Labor. So with that, I now turn it over to you, Bill.
Thanks, Brad. As an introduction today, Brandon and I have divided the topics, but someone asked me the other day saying, well, I see you're doing a webinar on FMLA. No, this is not an FMLA webinar. This is a webinar that deals with what do you do with someone's benefits when they either go out on FMLA leave, non-FMLA leave, workers' comp, or if they're out on military leave. We're going to divide up those topics. Brandon's going to cover the first couple of topics. I'm going to cover the last topics. Then at the very end of the webinar, I have a list of items that you should have in a leave policy. Now, only thing I can stress today is if you do not have written procedures on what you're going to do with someone's benefits when they go out on leave, that's a bad idea. Everyone should have some type of policy. And with that, Brandon, I'm going to turn it over to you to talk about FMLA leave.
Great. Thanks, Bill. When Bill this webinar was Bill's idea, and when he first mentioned it, I think, the one that asked him why we are going to do a webinar on the FMLA, because Bill and I, neither one of us are FMLA experts. But, leave of absences can create a number of issues for our employers. Often a leave of absence does not, necessarily end in a termination of employment. It's just someone is gone for a period of time. It could be for a number of reasons. And, the result of that, if you think about it from the health plan side, which is really what a lot of the discussion today is about, is someone has had a kind of a reduction in their hours. And so the question becomes, what do you do with someone who's out on leave and thus has had a reduction in hours? What are you required to do for them? And kind of how do all of these rules that kind of come together, kind of an intersecting set of rules between FMLA, COBRA, the ACA, sometimes workers' comp issues, how do they all kind of fit together? So, first off, the FMLA does not amend COBRA, but it does have its own continuation coverage rules. And these rules generally require an employer to maintain group health benefits for an employee that's on FMLA on the same terms and conditions as if the employee had continued to work. Generally speaking, when someone goes out on FMLA leave and they're entitled to continued health benefits under the FMLA, again, not under COBRA, under the FMLA, they're required to continue paying their portion of the premiums. The employer is required to continue paying its portion of the premiums. Coverage is, in a perfect world, supposed to continue. Before we get further into the weeds on FMLA leave, let's step back and talk about leaves of absence that are not FMLA leave. A leave of absence is a reduction of hours. So if the leave of absence, which is a reduction of hours, causes a loss of coverage, then COBRA must be offered. If there's no loss of coverage, then there's no COBRA event, and COBRA is not required to be offered. So if someone has a reduction of hours but their coverage continues, then there is no COBRA event. What about, the last bullet here on this slide says, okay, well, what about disability leave that is not FMLA leave? are there any special rules around that? Not really. The answer is if someone goes out on non-FMLA disability leave and they therefore have a reduction of hours, but there's not this added FMLA protection, then you kind of have the same issues. Does that leave, does it cause a loss of coverage? And if it does, then there's a COBRA event, and a COBRA notice needs to be given, and all the standard COBRA procedures need to kick into play. So FMLA leave provides up to 12 weeks or 26 weeks in certain circumstances of unpaid job-protected leave for certain life events, like, for example, the employee's own serious health condition. And as we've kind of alluded to a couple of times already, Bill and I are not experts on the FMLA. There are a lot of very specialized, nuanced rules that your kind of labor and employment attorneys can help you with. But generally speaking, this is what FMLA does. And again, it has its own continuation coverage rules that require employers to continue to maintain health benefits for an employee that's on leave. Well, okay, Brandon is goes on FMLA leave, and you know, every 2 weeks, or let's say every month, I'm required to pay $100 a month for my share of the premiums for health coverage. Brandon would need to continue, in my example, paying my share of the coverage or the premiums during my FMLA leave, just as I did when I was an active employee. What happens when an employee returns from FMLA leave? Well, generally, the employer is required to restore the benefits back just as they had when the employee left. So in a perfect world, what would happen if someone goes on FMLA leave, they continue to be covered by the employer's health plan, they continue to pay their portion of the premiums, they come back, and everything continues just as it had. So in a perfect world, the employee would not lose coverage. They would have the protection during the FMLA leave, and then when they come back, they're just reinstated. But what if they don't return to work? Then what happens? Well, if an employee does not return from FMLA leave, the COBRA event occurs at the end of the FMLA leave period. So COBRA does not occur when FMLA starts. COBRA occurs at the end of the FMLA period. The slide here that says COBRA event occurs when, and there's 1, 2, 3, you know, it lists the employee is covered on the day before the first day of a FMLA leave. I want to stop there for a second and kind of give you something to think about. So Brandon goes on FMLA leave. I just told you that Brandon's required to continue paying his share of the premiums during FMLA leave. What if during FMLA leave Brandon does not pay his share of the premiums? Well, the health coverage can be discontinued during the period that Brandon failed to pay premiums during the FMLA leave. But what if at the end of the FMLA leave Brandon comes back to work? Well, is Brandon entitled to get back on the employer's health plan? I believe he is. What if he does not come back to work? So we've had a situation where Brandon, during FMLA leave, failed to pay premiums, loses coverage, and then does not come back to work. Do we have a COBRA event? Yes, because bullet number 1, the requirement number 1, said Brandon was covered the day before the FMLA started. So you could have this weird scenario where Brandon loses coverage during FMLA leave, but at the end of that leave period, he still has a COBRA event because he was covered prior to the beginning of the FMLA leave. And then the other 2 events are requirements there are not as remarkable for us to discuss, but generally speaking, the employee doesn't return at the end of the leave period, and they would lose coverage but for the COBRA continuation. Okay, so the COBRA maximum coverage period generally begins on the last day of FMLA leave, and it can begin following a 12-week or 26-week FMLA leave period. And one of the questions that I was kind of looking at when I was getting ready for this is, well, when is the last day of FMLA leave? And it would be when the employee doesn't return to work, or it could be earlier than that if the employee expresses a clear intent that they're not coming back. And again, this falls into the category your labor and employment lawyer needs to help you make sure that you're comfortable that the FMLA period has ended, before the 12-week period, for example. If an employee comes to you and says, I'm not coming back to work, at least under the guidance that we've read getting ready for this discussion here, your FMLA leave ends at that point and your COBRA event occurs. Okay, so what happens, I've already mentioned this, but what happens if the employee fails to pay the portion of premiums during the FMLA leave and then fails to return? The answer is they could have a COBRA event nonetheless because they were covered before the FMLA leave started. What if after the FMLA leave is complete, the employee is allowed to continue under non-FMLA leave? Well, interestingly enough, there is some discussion that if Brandon has a 12-week FMLA leave period and he's entitled to continuation coverage during that period under the FMLA rules, and then you as an employer are more generous and you give more time that is not FMLA leave, well, what happens if you allow Brandon to continue to pay his premiums and continue to be covered? Well, kind of my first question is, and Bill, what's your thoughts on this, is I think you need to make sure your health plan document allows you to continue covering someone who's out on a non-FMLA leave. What do you think, Bill?
I think that's a good idea, Brandon, but you have to have your timeline out, and you have to follow the policies and procedures under COBRA. If I get 12 weeks of FMLA and another 10 weeks of non-FMLA leave, in order to follow the terms of your medical plan document and to comply with COBRA, you have to give a COBRA notice at the first day of that non-FMLA leave. Now, you may have a policy where you pay 100% of the premiums or a portion of those premiums, but you can't wait to give that COBRA notice at the end of the non-FMLA leave.
I think if we on this slide and this point, I think this is an important illustration of why these leave policies can be problematic, because sometimes our employers are more generous to their employees and they don't really think about the impact of being more generous on COBRA. When is the qualifying event? Was it when you extended the leave period beyond FMLA or was it some other time? So it's something you need to be thinking about when you are more generous to your employees. Okay, USERRA is, USERRA basically provides also for health plan continuation coverage rights for folks that are absent from employment by reason of military service. The interesting thing about USERRA coverage or continuation coverage is, and I think this is important, is USERRA can apply to a broader group of employers than COBRA does. COBRA, for example, has this small employer exception. If you have, I think it's fewer than 20 employees in the preceding year, you're not subject to COBRA. USERRA, there is not a small employer exception, and so USERRA could, even for our employers that are not subject to COBRA, they may have a requirement to continue coverage for those that are on military leave, even though the employer is not subject to COBRA. Interesting thing also about USERRA is, unlike COBRA, under USERRA, only the employee has the right to elect continuation coverage, not a spouse and not a dependent, but the employee can elect coverage for themselves and their dependents. I don't know about the folks listening on this webinar today, but I don't deal with very much. I don't get a lot of USERRA questions. Periodically we do, but Bill, we really don't get that many.
Not very often.
We get a lot of COBRA questions, a lot of ACA questions, but we don't run into USERRA a lot, and so it's important just for you folks and we put it in here just so you would be aware of it and think about it for those on military leave, and just know that it has its own kind of special, unique rules. So an employee who loses coverage because of military leave, they're protected by COBRA and USERRA. And it's important to know when the requirements between COBRA and USERRA differ, and there are differences, the employee or the dependent is entitled to the law that provides the greatest level of protection. So you kind of interpret those rules together to give the employee the greatest amount of rights and benefits. USERRA requires employers to post a notice regarding employer rights in a certain form that's required by the Department of Labor. There is not a requirement to give some sort of an individualized notice of health care coverage rights or continuation coverage rights to employees like there is under COBRA, but you do have this requirement to post a kind of a generalized notice in a certain DOL format. COBRA and USERRA election periods generally begin at the same time, but they have different maximum coverage periods. So what I'm saying is you could have a situation where someone loses coverage because of military leave, and you could have simultaneously, that employee could have rights under USERRA and COBRA. USERRA leave is longer than COBRA. COBRA generally is 18 months. Again, generally, USERRA is 24 months. So you may have a situation where you run the first 18 months of someone's leave, or military leave, they are protected by COBRA and USERRA, and then there's an additional 6-month period tacked onto that where they have the benefit and protections of USERRA. So I'm going to turn it over to Bill, and Bill's going to talk about workers' comp and leaves and impacts on health plans of workers' comp and the ACA.
Thanks, Brandon. Moving on to workers' comp, this has been a very controversial issue for, the past 10 or 15 years, and plaintiffs' attorneys, they take the position that, hey, you cannot terminate health coverage while someone's out on workers' comp, and we've taken the opposite view. Now let's talk about what happens when I'm out on workers' comp. What's the qualifying event? Well, again, it's the reduction of hours. And in the state of Oklahoma, the plaintiffs' attorneys have taken the position that our Title 85 laws under workers' comp basically have protected a participant who goes out on workers' comp, they're not working any hours, that you can't terminate that coverage under workers' comp. Well, our position has always been, no, that state statute is preempted by ERISA. Your health plan is an ERISA plan, and we have cases. I've cited one case, but there are multiple cases that cite that the state workers' comp laws are preempted. Now, what happens with these issues when you're dealing with state workers' comp laws? Well, you have to be prepared, because if you have a injured employee who's out on workers' comp and they're represented by an attorney, you're generally going to get a letter stating that you're in violation of our state workers' comp laws, that you can't terminate coverage. Now, Charlie Plum, who's an employment lawyer in my office, most of you have heard Charlie speak. Well, it's an ongoing issue with plaintiffs' attorneys where we'll write back and say, well, if you believe that's correct, you need to file suit and bring this action in court. Well, we've never had one actually sue us. So it's an ongoing issue, and I have a lot of clients who say, I can't terminate that coverage if they're on workers' comp. Well, that's not correct. Now, in Oklahoma, this has been corrected under the new workers' comp statute. That language that says you cannot terminate coverage because you're out on workers' comp, it's been removed from the statute. However, if you're working in multiple states, I would say the majority of states still have language in their statutes that state you can't terminate coverage if you're on workers' comp. And again, we do not believe that is the correct interpretation if your health plan is an ERISA plan. Okay. Again, when someone goes out on workers' comp, what's the maximum period of coverage? Again, it's 18 months of COBRA continuation. Now, there are special rules, especially on workers' comp. If someone goes out on disability leave in connection with workers' comp, you might get the extended 29 hours. Now, the big question is, do we treat workers' comp any different than we treat a normal leave of absence? And the answer to that is no. But again, we have exceptions. The number one exception that I see is if you have a policy or a plan document that extends workers' comp leave and it's not treated as a qualifying event, you can do that. And under the COBRA statutes, it allows you to say, I'm extending the period of time, and while someone's out on workers' comp, we're not treating that as a qualifying event and not terminated for COBRA. You can do that. However, I see a lot of my clients who are on a fully insured contract, say with Blue Cross and Blue Shield, United Healthcare, Preferred Community Choice. None of those policies have the language to extend coverage. But I do have a number, and Brandon, you too, have a number of self-insured clients where they put in that special language to extend the period while someone's out on workers' compensation.
So you're allowed to provide the coverage, but you're not required to, is what you're saying, right? Under the statute's preempted as to a self-funded ERISA-based plan, but if the employer wants to be more generous and provide the coverage during workers' comp leave, they can. Is that what you're saying, Bill?
That is correct. Now, if I extend my workers' comp leave extend the COBRA period, and I'm a self-insured plan, I highly recommend that you get that approved by your stop-loss carrier, because if they're not aware of that extension and they haven't read that in the plan document, that can create some serious problems. And again, FMLA leave is another exception to that, because many times when someone goes out on workers' comp, they're also going to qualify for the 12 weeks of FMLA, and at that point in time, workers' comp, FMLA, your qualifying event is not going to take place until after 12 weeks. Okay, now, if you're sitting there and you're saying, yeah, I've got this fully insured contract, I have people out on workers' comp, and I have a plaintiff's attorney or employment law attorney who's told me that I can't terminate coverage in the state of Oklahoma. Now I'm listening to this seminar, and someone's telling me I should have terminated the coverage. What do you do? Well, again, I've dealt with this for over 15 years, and I have not had anyone prove me wrong that you're out on workers' comp, you have to treat it as a qualifying event for COBRA if I'm not working the required hours to stay on the health insurance policy. So what do I do to correct this problem? Well, you need to mitigate your damages. I wouldn't just ignore this problem. I would mitigate the damages, and I would send a COBRA notice immediately saying, we've missed the COBRA date, we're late, but we're sending you the COBRA notice today. You want to stay on our health plan, you are going to have to start paying your share of the premium as a COBRA participant, and you're going to have 18 months of coverage from the date of this notice. And at the same time, I would contact my insurance carrier. And this happens all the time. Most of the time, the insurance carriers will say, we understand it was a mistake, it's a complicated area, and in most cases they said, listen, we will honor your mistake, and we will cover the extended period of time for the 18 months from the date that you sent the notice. I want to give an example. I have ABC Company. They've allowed an employee to remain on the employer's health plan for 12 months after a workers' comp injury. ABC discovers the problem 12 months later, and they send an untimely COBRA notice. The employee elects an additional 18 months of coverage from the date the notice is sent. However, I have Heartless Health Insurance Company. They're saying, no, we're not going to cover that period of time where you made a mistake. We're only going to cover the last 6 months. Well, what's your liability? Your liability states that for that last period of time, the insurance carrier is going to cover the first 6 months. You're going to cover the last 12 months. You're paying those premiums, not premiums, you're paying all of the claims out of your general assets. And unfortunately, we have had that happen in real life.
One thing I might mention here, and Bill has already mentioned, but just to highlight the point, is that if you discover a situation where you've made a mistake with COBRA, make sure you're real careful about what's in your COBRA notice. You don't want to just send out your generalized COBRA notice that you would normally send when you did things right. You may need to draft it specifically for the problem you have.
And let's go to the timeline. In my timeline, I have someone who goes out on a workers' comp injury on January 1st of 2014. On 1/1 of 2015, you're doing re-enrollments of benefits, and you discover that you made a mistake. This person is out on workers' comp. They're not working the 25 hours a week or 30 hours a week that you have to have in order to have health insurance. So on 1/1/15, I send out a new COBRA notice. And again, I would attach a letter explaining what has happened or change the COBRA notice. Now, the insurance carrier is saying, you should have started that COBRA period on 1/1/14. We're only responsible for the last 6 months from 6/30/15. Well, I've got 18 months of coverage starting 1/1/15. For these last 12 months, I'm going to have to go to my boss and say, hey, we made a mistake on the COBRA, and we had someone who went out on injury, and by the way, it's a fairly significant injury, and it's high cost, a lot of claims, and we're going to be paying all of those claims for the next 12 months. Now, that's one of those situations where you're going, oh, my God, am I going to keep my job over that or not? So, again, taking corrective action, you want to send a COBRA notice immediately, contact your insurance carrier, contact your broker, contact your consultant, contact us or another lawyer to see if they can help negotiate with the insurance carriers. Happens a lot with Blue Cross and Blue Shield, and they've been pretty good. Haven't you seen that, Brandon? To say, yes, it's a mistake, don't let it happen again, and we're going to cover you.
Yep.
Okay. Now, we've talked about a lot of rules today about when COBRA starts, and now throw some of those rules out the door because it's going to get a little bit more complicated when we add the Affordable Care Act. Now, under the Affordable Care Act, we know that in order to be covered by a health plan, the minimum number of hours that you can require is 30 hours per week. Now, that's not as easy as it sounds. Most of you know there's 2 ways to count hours. There's the monthly look-back method, and then there's the year-long look-back method. If you're using the monthly method, basically that rule states that if you don't work 130 hours in any given month, you're treated as a terminated participant. And that applies to a lot of our employers who don't have part-time employees. But then we have the industries, we have hospitals, we have retail, we have, Brandon, what are some of the other industries?
Food service.
Food service.
Yeah.
It's very, very difficult to determine, are my employees working 30 hours per week? If I use this look-back method to determine whether or not I have a reduction of hours, I have to look at the look-back period, and I am going to be locked in for the full 12 months during the next stability period, and that my COBRA event will not occur until at the end of that stability period. Here's an example. I got ABC Company. They determine its employees, whether they are a full-time employee by using the look-back method. And in my example that I'm going to show on the timeline, my measurement period begins each October 15th and ends the following October 15th. And then I'm going to have a small administrative period in between. And then I'm going to have a stability period that starts on January 1 and doesn't end until the following December 31st.
And in this example, I think a big number of our population listening to this webinar has listened to all of our other seminars on the ACA and how these crazy measuring rules work. But I think it's helpful to kind of put years so that people can, so in this example, we might say, to make it more clear, the measurement period begins, let's say, October 15 of 2014 and ends the following October 15 of 2015. And then the stability period, if someone averaged 30 hours during that 12-month period, they would have coverage or be extended coverage for all of 2016, regardless of whether their hours go up or down during 2016, right?
Right. That's exactly what Brandon has said on the timeline. October 15th of 14, we start our measurement period. That measurement period goes until the next October, and my stability period starts on 1/1/16. And in my example, let's say I have an employee. They're locked in. They go out on type of non-FMLA leave after 1/1/16. And if I go out on leave anytime after 1/1/16, I'm locked into this plan all the way to 12/31/16. My COBRA event does not start until December 31st, 2016. And again, you need to have policies and procedures, because here's a major problem. I have a health plan. I have someone who's getting extended coverage all the way to 12/31/16. But I may have a life insurance policy that says after X number of months, X number of hours, that's treated as a termination, and I should have given a continuation notice. And so here I kept this person on all their benefits, and they die at a certain point in time, and it comes to pay that life insurance claim. Well, I find out later on I should have stopped the life insurance, should have given a continuation notice, but I should have kept them on the health insurance. So again, as I get to the end of this, I'm going to talk about how important it is to have a leave policy where you outline all of these different scenarios. And that's where I am now. And this is where I'm going to spend quite a bit of time. Everyone should have a leave policy for benefits. Well, out of the 400 people listening today, I would be shocked if more than 25 of you have actually prepared a leave policy, because this is an issue that we deal with all the time. I probably have 6 or 7 hot issues dealing with someone who didn't comply with COBRA or their leave issues, and I'm going to give some real-life examples. But here's what I'm going to do when I design a leave policy. First thing I'm going to do on the front page of my leave policy, I'm going to have 4 columns. And in column 1, I'm going to list every benefit plan that I offer to my participants. In the second column, I'm going to put whether or not the employer pays 100% of the premiums. And I'm going to put a check mark there. And then on the third column, I'm going to state, well, the employee either pays all or a portion. And I'm going to identify that. And in my fourth column, I'm going to identify in each one of these policies, when does coverage terminate? When does it terminate? And if it does terminate, what is my notice period for providing a continuation form or a conversion form on my life insurance or on my disability?
Bill, what are some of the examples of the benefits that you put in that first column that you list out there, for folks to be thinking about besides the health plan?
Well, again, my first one is my medical plan. Second one is my flexible spending account, which is subject to COBRA and for continuation. I have group dental. I have vision. I have the basic life that the company provides. I have the voluntary life that the company provides. I have paid company AD&D. I have voluntary AD&D. Then I have short-term disability. Do I provide it, and what happens on short-term disability? Then I also have my 401k retirement plan.
And so this policy where you list out all these different kind of the menu of benefits you offer, really help an HR person figure out what happens when someone goes on leave of any kind, and so that they can know not just how it impacts the medical plan, but all the other benefits you mentioned as well.
Absolutely. And I'm going to have, in my fourth column, I'm going to have a site. And that site is going to tell me the page number and the section of the document that deals with termination of coverage, continuation of coverage, how it interrelates with FMLA and non-FMLA coverage. Okay? Now, my next step is I'm going to address FMLA leave. And under the FMLA, first thing in this policy is, okay, during FMLA, am I going to require this employee to pay up front? I don't see that very often when someone goes out on FMLA, because normally they don't know how long they're going to be gone. And I've actually never seen that happen where an employer requires them to pay up front for all their coverage. Number 2, pay as you go. That is a very popular option. Pay as you go Or the third option is you pay at the end of the leave. Now, I don't know if that's the best policy because someone's out for 12 weeks, they get coverage during that 12 weeks, and then they don't come back. And it would be very hard to collect for someone who does not come back. Number two, under this FMLA policy, you need to address what happens if Brandon does not pay his premiums during FMLA. If they're out for a month, and they're going to be out for 2 more months, and again, they're not working, they can't pay for the coverage, you need a state. Well, am I going to terminate coverage in the next 30 days, or am I going to extend coverage? Am I going to pick up the coverage and try to collect? That's very important to have it in your policy on how you're going to treat non-payment of coverage. Then again, you need to address how do you determine what is the date of your qualifying event. And it needs to be written in your policy that if a layman picks up this policy, that they know that the COBRA qualifying event takes place at the end of that FMLA period, even if they haven't paid their premiums. Okay? The next issue is workers' compensation. Now, in my workers' compensation, if I'm a self-insured plan, I need to decide, am I going to continue health coverage during the period of time that someone's out on workers' comp? And if that is true, I need to make sure I address that in my leave policy, and I also need to have that written into the terms of my plan document. Now, if I'm a fully insured plan, generally, you're not going to be able to do that. You can't modify a insurance contract that's filed with the state of Oklahoma. So that's generally not going to be an option. Here is the most important thing that you have to deal with. You have policies and procedures in place to notify participants of conversion and continuation rights in regards to your life, disability, and your AD&D plans. And this is a very common mistake, unfortunately, that I've dealt with many times in my career. I'm going to give an example. I have a company, they have 100 employees, and they have a CEO, and he's a really good guy. He built this company up from scratch out of his garage. He's had some employees that have worked with him for 30 years, had a key employee who went out with terminal cancer. And he didn't want to leave this employee high and dry during this period of time. We knew this employee, well, I didn't know, but he knew that this employee was not going to live past 12 months. So he tells the spouse, I'm going to keep you on all the benefits and full salary during this terrible time that you're going to be going through over the next 12 months. It was a great deal. So he keeps the employees on all the insurance. He doesn't give a COBRA notice, doesn't give a conversion notice, and this employee, unfortunately, passed away. Well, after the employee passes away, the spouse files a claim for life insurance benefits. Well, insurance companies who have to pay a large claim, let's say if I have pay a claim $300,000, $400,000, $500,000, they normally do an investigation and want to see the medical records. And in this case, they did an investigation. And they said, listen, this employee was going through intensive chemotherapy, intensive treatment. We're reading the medical file. There's no way this employee could be working. Well, our argument was, well, even though the employee was not in the office every day, he and the CEO talked at least once a day, and he would make it into the office a couple times a week, and he was engaged with the CEO. He wasn't terminated. And we didn't win that case because the insurance company was able to prove that you had to be working 20 hours a week, actively employed in some capacity in order to stay on the life insurance. And what happened was we didn't win the case, and the CEO ended up writing a personal check for multiple six figures to this spouse of this deceased participant. What they should have done, it's okay to keep someone on payroll, but at the given time, you need to make sure you give the proper COBRA notice, You do not want to be stuck paying for high-cost medical care if you haven't given the proper COBRA notice. And then whatever the terms are in your life plan, your disability plan, your AD&D insurance, make sure you have procedures and you're identifying these issues. If you're a small company, and we see this all the time, and you have a great CEO who wants to take care of their employees, you're going to have to warn them that there could be some very, very bad results if you're too generous with your employees. Now, my suggestion is if you want to keep them on, you do the continuation, or you do the conversion, you do the COBRA, but there's nothing that states that you can't pay for those premiums while that person's out.
And there probably in that scenario would have been right, had it been done correctly, for the individual to convert that life policy to an individual policy, right, Bill?
Absolutely.
So you probably could have achieved the same result that you were wanting, which is continuing to fund the salary. Let the individual convert that life insurance policy to an individual policy. You might even help them with the premiums, and then you don't have that issue.
And also, under this case, there was a disability policy, and they should have actually filed for a disability claim and gone out on disability. And generally, when you're out on a disability claim, you have what's known as waiver of premium under your life insurance, and you wouldn't even have to pay the premiums. So by being too generous, it just didn't work out in this case. The next thing that you want to have in your policy is what happens on non-FMLA leave. Payment of premiums, if you fail to pay the premiums, and when do you actually give that COBRA notice? Or are you going to extend the period of COBRA? Again, this is something that a lot of people don't know, that even though COBRA is only for a 18-month period of time, the statute allows you to extend the COBRA period. You can extend your COBRA period for an additional 24 months if you want to for an employee. And for a fully insured plan, you can discriminate all day long on the extension of the COBRA period. I've had one plan extend COBRA for 3 years, and we got approval from the insurance company to do that for a group of employees that were out on leave. You need to address the military leave. If you're out on military leave, and again, I don't have that many questions on military leave, maybe once every 2 or 3 months.
You know what struck me, and I don't either, we kind of mentioned this, but the Bill, it seems to me like the folks listening might want to look back and see if they have the right USERRA notice. I don't, to be honest with you, Bill, I don't know that I've ever looked at a USERRA notice for a client. And so I wonder how many folks listening to this webinar are aware of whether they have a USERRA notice and whether it's posted, whether it's in the right format, that kind of thing. So that might be something, and I don't, by the way, think you need our help for that. That might be, it looks like it's a standardized DOL form, but it might be something you want to double check.
And again, that's a good point, Brandon. You can go out on the DOL website and you can get a copy of USERRA notice or an updated USERRA notice, and they do a very good job of talking about what happens when an employee goes out on military leave. The last issue is if you have a retirement plan and someone goes out on leave and they have a loan, do you suspend the loan during that period of time, or are you going to require them to continue to make payments on that loan while they're out? That should be in both your loan policy and this leave policy. And the last issue is, if I have a 401k plan, has there been a severance from employment? In a 401k plan, you cannot take a distribution before age 59 and a half if there hasn't been a severance from employment. And again, I have employers who are wanting to be generous for their employees, and they say, well, for this purpose, they're still an employee, but for that 401k plan, we're going to treat them as terminated, and we're going to give them a distribution from the plan. And again, on the IRS audits and DOL audits, that's part of the audit process. Are we timing distributions correctly?
One thing I'd like to kind of go back to there is the mention of the loan policies. A lot of you may not know, if you make a mistake with a plan loan, a retirement plan loan, the only way to fix it correctly is to go file a VCP with the IRS and pay the filing fee and get their blessing to unwind it. to unwind the problem. So plan loans are significant. Well, we see a lot, unfortunately, to Bill's point about the loan policy and making sure when someone goes on leave that you're aware of what your plan and your loan policy say. We see a lot of clients that don't have a loan policy. Their plan document may require a plan loan policy, and people don't have them, or if they have them, they're really outdated. I can tell you just from our firm's perspective, we had to update our loan policy recently because our loan policy, we hadn't looked at it in a long time. So make sure you know what it says in your loan policy about when someone goes on a leave of absence, and make sure that the loan policy is consistent with your overall leave policy that Bill was talking about.
Right. And that's a good point, Brandon. Again, this is a project that I would highly recommend for any client to go through and do a leave policy. And then again, if you need help with drafting a leave policy or getting this project started, this is something that myself and my associate attorney that works closely in this area, Barbara Klepper, if you need help, you can either contact myself. It would probably be much more efficient to contact Barbara Klepper because I will just push that down to her. But if you need help and want to contact her, you can email her, and her email address is barbara.klepper@McAfeeTaft.com. And if you have any questions, you can call her, or if you need help with drafting a policy, and again, we've done many of these policies, she can help you.
I want to thank Bill Freudenrich and Brandon Long for presenting today's webinar. And on behalf of the law firm of McAfee Taft, thank you for joining us for another Employer Link webinar. See you next time, and have a great afternoon.